not the Andersons, I mean, taking the legal standard, whether or not the Andersons in this circumstance, given the information that you know, looking at, you know, how the courts, I guess, have analyzed the issue previously.
Here's what I don't understand, is they could, you know, the Andersons made lots of complaints and wrote letters regarding win one. Why didn't they do that for win two? Why didn't they also say win one and two?
Mm-hmm.
Well, that would go to their standing, right, where they agreed by win two.
Oh, okay, you could look at it that way.
There's a timeline if it helps, I don't know, timeline material, oops, there goes something.
Yeah, we have a partial timeline.
Yeah, here's a timeliness and latches timeline, if you want to look at it, it's in the materials Mr. Seti gave, dated July 28th.
Right, but that only goes to October 2010, correct?
Yeah, but it covers our first 30-day period.
Right, I understand. Yeah. And I don't. So according to this May 5th, the elders requested that win two be stopped on May 5th.
So they had, obviously,
Mhm.
knowledge of win two, on May 5th. Actually, I'm sure before May 5th, because
Right.
they met with the assistant town manager on May 5th. So there, I guess that goes to Ed's point, that there may have been a general, or probably, a general knowledge, at least to people who were being affected by win one, about win two.
Of course, May 5th is after April 18th.
It is. But the win one began operating April 6th. So that still leaves 12
April
days
6th.
if you were
Yeah,
concerned.
you know, that 12 days, how is not an enormously long period of time to experience something, you know, whether you, maybe you think, they're just starting up, it's gonna get better, I'll.
But the first complaint was March 30th, even prior to them operating consistently.
Yeah, it's still short.
It's unfortunate that the case law gives us only one person to examine the conduct of in Chilmark, who had, you know, hung around this for a long time and obviously missed the deadline. So I think what you have to do is sort of compare. I think you have to ask yourself, what would a reasonable person have done within that first 30-day period?
You know, this is a little different than, say, a structure going up where you know the structure's there. This is a response to the operation of something, right?
Well, and it wasn't even, win two wasn't operating.
Well, that's for sure true, but
And wasn't
in this
being
case-
constructed within that period. So you don't really have a sense of location until well after, until it was constructed. So, and I know that the town, I think Attorney Tillotson kind of concedes, well, do not contend actual notice by the parties. So they're not saying they actually knew, they're saying they had constructive notice. And I think she pointed to the list of abutters, the Energy Commission updates, which I think there was some question. I know the abutters, or I shouldn't be saying abutters, but the people on that list contend maybe they didn't receive that.
Would it help if I read Richardson's facts and you could then compare them?
couldn't hurt.
A party has constructive notice when the evidence is, quote, sufficient to place on that party a duty of inquiry regarding the building permit's issuance. The following undisputed facts lead us to conclude that although difficult questions concerning the adequacy of notice may arise at the margins, that's a quote from Connors, Carlin had constructive notice of the issuance of the permit on September 11th, 1999. By that time, this is what had happened, Carlin had hired an attorney to assist with her opposition to the proposed construction on the Cohen property. By his own admission, the lawyer had seen plans of the proposed construction, had been intimately involved in all the proceedings and met with members of the town. Carlin had vigilantly monitored Cohen's plans for construction and fought his efforts at multiple steps. In April of '99, for example, she filed a complaint in the Superior Court appealing the issuance of a septic system upgrade permit. In the complaint, Carlin acknowledged Cohen's plan to build a large single-family dwelling. These undisputed facts establish Carlin's awareness of Cohen's intention to begin construction as soon as possible.
I don't think we have those facts here. I think there were complaints lodged during the period, some complaints about Win 1. But I don't think that we have facts before us.
I guess what's bothering me is if someone is putting up a structure that you deem encroaches or, there's some reason why it shouldn't be there, it's in your right of way, whatever. That's very clear cut. The structure is going up, you object to the structure itself. As opposed to some result of the use of that structure subsequent to its construction. So, yeah, the wind turbines look great. I'm all for green power. Then they go on. My God, these things make noise. They're bothering me. How constrained are we by this time period? Because I don't know that it's an appropriate time period.
Well, look, the facts of the matter are that they did not get actual notice because nobody mailed it back. They didn't walk through town hall as Connors did and get notice in another fashion. And the behavior of Carlin in the Richardson case was what it was. I read you what she did and her lawyer did. So I think the answer is in that basis for comparison. That's the case that says you have a duty of inquiry. If you see the facts in this case as being as compelling, there was a duty of inquiry. If you think that because there hadn't been a long history of looking at this and there was no way to know.
No way to know what the impacts were the instant it went up. And even, perhaps, for some weeks after, as, they're tuning it, they're adjusting the blades, who knows what they're doing.
Remember that there's not only a question of impacts here, but an equally weighty question of the procedures used to put it up. So even if the impacts were not known, the procedure to get the building permit is a separate matter altogether, and it was ultimately decided that a special permit was required. For Win 1.
So how would you guys like to proceed?
I think the fact that there was notice before the first one was built, because they had taken people to someplace in Hull or someplace to just observe things because there was a concern for noise. I would think everybody would be concerned from day one on the first one. If that's a concern, you ought to pay attention, if you're concerned about noise.
We've kind of focused though on the three appellant
Yeah.
representatives here.
I think in my position, hearing the facts that you read, again, and I have read the case, but I think when you isolate them, in that case, Carlin was definitely aware that the permitting was coming, that it was coming, and so she should know that any day the permit might be issued and that 30 days starts to run. And here, I don't think from the get-go that people knew that the building permit for Win 2 was going to issue, and I don't think on the basis of the information that's before us that they had a duty to inquire within the 30 days, so
Yeah,
that's
I agree with you.
how
I
I feel
agree,
like
yeah.
that's.
Again, I go back to, people being unfamiliar with that process, not, I didn't know a lot about these wind turbines when they were going up. busy. If I saw it, it was in the Falmouth Enterprise, if I cared to look at it, it's very easy for somebody not to be aware of what's going on. You know, so,
But if
I
you have
agree with Jim.
construction activities, and, I mean,
yeah, but this is,
these
but,
people were differently situated than
Oh, yeah.
us as,
You're talking Anderson, remember this is
Right.
Anderson.
these are the Andersons. And
Right.
so they did have complaints as early as March 30th for Win 1. Kevin or TJ?
To play devil's advocate a little bit here, we had Win 1 up. Win 2 was coming, and, you know, I know the argument was made, well, if it was Win 1, then that implies that there was at least a second one coming up. Just because you name the turbine Win 1, I don't think that necessarily puts you on notice that Win 2 would be built on the same property, could be another public use district in town. So I'm not sure if we quite get to the duty to inquiry there.
And they were certainly staggered. You said 2008 for the first building permit, it just happened that the second building permit was applied for, and then it wasn't constructed for a period. So the notion that this was an imminent thing or was coming soon, where they should be monitoring it. I know that there was a general discussion in the town, you know, multiple turbines, but to say that that was sufficient, that they should be calling every day and seeing when that permit issued, I just don't think that the facts are in front of us. I don't know.
No, I'm okay with that. I'm troubled by the, as I say, that why would you necessarily inquire until you knew it was gonna have an impact on you? So if you had an open mind towards wind power, you might not inquire until these things went up and started bothering you.
Okay,
So is there,
consensus here, or I think Ed's going to be
Yeah,
the outlier, but does everybody else say that the Andersons, and I would think that the inquiry's pretty much the same for the fun cars, but I don't wanna speak for other people. I think the Andersons were the first to make the complaint, so if we say they don't have knowledge and there's nothing else in the record to suggest that the fun cars had knowledge or a duty to inquire, I think we could reach at least that question.
Okay?
Is everybody there?
yeah.
So, okay, so I think we know how it feels.
so does that apply to both the Fun Park and the Anderson?
It does for me.
For me as well.
Yes. And Ed says they should have known.
no, I'd say.
They should have inquired.
Everybody should have said something. To me, there was a raft of information available in the public domain. And if you were concerned about your own health, I think I would have been looking in the paper every Friday, or whatever day the enterprise was up.
Okay, so that is that question.
Okay, now we
Yeah.
move on. I think what I'm recording is 3 decisions by a 4-to-1 vote that neither Fun Cars, the Andersons, or Linda McCollum had a duty to inquire or actual notice of the issuance of the building permit in March of 2010.
Yes.
Now we look to the back of the period, knowing that there's a 6-year statute of limitations. So the appeal of Win 2 was filed in June or July of this year, seeking enforcement. Is that right, June? And the building permit was issued on March 18, 2010. So that's a 5-year, call it 2-month, 3-month gap between the 2 dates. And the question it then raised is the one of the latches. Was that a reasonable period of time?
Can you remind me when Win 2 became operational?
It's February 12th.
Yeah, February 12th.
2012.
And would you remind me when the first enforcement request was made for Win 1, and the board voted 3-1 to require the special permit? I was here for that. Was it 11?
2011 is correct.
I believe it was 2011.
Yes.
Let's be sure.
Sorry?
Is anybody sure of the date?
I would check the Anderson file.
Do we have a copy of the appeal court's drawing decision here?
Oh, I might have that in there.
Everybody's got copies.